If a stranger walked up to you on the street and said, "Hey, sign this. It says you give up your right to sue me, you authorize me to share your medical records with tech companies, and you agree to let my guy, not a judge, not a jury, decide any dispute we ever have," you'd walk away. But last time you were at a hospital, someone handed you that exact document. You were in pain, or you were scared, or you were in a hurry, and you signed it. Because they called it a standard admission form. Stick with me, because by the end of this video, I'm going to show you the exact words you can write on that form that change everything. Picture this. You scheduled a procedure 3 weeks ago. Nothing major, a knee surgery, a gallbladder removal, a routine colonoscopy. You've been planning for it. You arranged time off work, you got a ride, you walk in, you give them your insurance card, and before anyone checks your blood pressure, before anyone asks about your medications, before you even sit down in the back, a clipboard lands in front of you. Or maybe it's a tablet. A lot of hospitals use tablets now. Either way, the person behind the desk doesn't look up. They just say, "I need you to sign here, here, and initial here before we get started." You're already a little nervous about the procedure. There's a waiting room full of people behind you. The pen is already in your hand, so you sign. Here's what nobody tells you. That stack of papers isn't just consent for treatment. Buried inside it, in the same font with no warning, no asterisk, no explanation, is a legal contract. Not a medical document, a legal contract. One that was reviewed by the hospital's attorneys before it was ever printed. One that was specifically designed to be signed by someone who is distracted or scared or in pain or running late. One that in most states is fully enforceable the moment you put your name on it. It's called the Conditions of Admission or the Conditions of Treatment. The name changes depending on the hospital. The contents largely don't. And today, we're going through every clause. Let's start with what this document actually is. The Conditions of Admission is a standard intake contract used by hospitals across the United States. It looks like paperwork, it feels like paperwork, but buried inside it are clauses that have nothing to do with your medical care and everything to do with protecting the hospital if something goes wrong. Most forms commonly include some version of these 5 clauses, and you need to know all 5. The first one is the assignment of benefits. This clause redirects your insurance payment directly to the hospital, bypassing you entirely. You're not receiving money and then paying the hospital. The hospital is receiving it first, and you're authorizing that before you've been treated for anything. The second is the financial responsibility agreement. This one says that if your insurance doesn't cover something or denies a claim, you are personally responsible for the full balance, not a negotiated rate, the full billed amount, which, as most Americans have discovered the hard way, can be a number that has very little to do with reality. The third is the consent to treatment clause. This one is legitimate. It's what allows doctors to treat you. But pay attention to how broad the language is. In many hospitals, depending on your state, this clause authorizes procedures beyond what you specifically came in for, as long as they're deemed medically necessary at the time. The fourth is the release of medical information. Under HIPAA, your records are protected, but this clause is where hospitals expand those permissions. Many forms include language that authorizes sharing your records with third-party partners, research institutions, and increasingly, technology companies. And then there's the fifth one, the one that's different from all the others. It's not about payment, it's not about consent, it's not about insurance. It's about what happens if the hospital makes a mistake and you try to hold them accountable. That clause is called mandatory arbitration, and it may be the most consequential thing you've ever signed without knowing it. Here's how arbitration is supposed to work. Instead of going to court, both sides agree to bring their dispute to a private arbitrator, a neutral third party who hears the case and makes a binding decision. Faster than a trial, cheaper than a trial, and private, which means no public record. That sounds reasonable, and in some contexts, it is. But here's the problem with mandatory arbitration in a hospital admission form. You didn't negotiate it, you didn't choose it, you didn't even know it was there. The hospital's lawyers wrote it, and in many cases, the hospital has an ongoing relationship with the arbitration provider because they send them cases regularly. You, on the other hand, will probably never use them again. And here's what you give up when you sign it. No jury. In a regular lawsuit, 12 people from your community hear what happened to you and decide if it was negligent. In arbitration, one person decides, and that person was not chosen by you. No appeal. If the arbitrator rules against you, in most states, your options to challenge that decision are extremely limited. You can't go back to court and start over. No public record. When hospitals lose in arbitration, nobody finds out. There's no public filing, no precedent, no warning for the next patient. In 2012, the United States Supreme Court made this significantly worse. In a case called Marmet Healthcare Center versus Brown out of West Virginia, the court ruled that states cannot simply ban mandatory arbitration in healthcare contracts. The Federal Arbitration Act, they said, overrides state law, which means that even in states that tried to protect patients from this practice, the federal government stepped in and said, the clause stands. And the hospital's attorneys know this. They were counting on it when they wrote the form. Now, I mentioned there's one state that found a way around this, and there is. But before we get there, there's another clause in that document that almost nobody talks about, one that didn't exist 10 years ago, one that was quietly added to admission forms across the country while everyone was looking somewhere else. Stay with me. You just learned that the hospital took away your right to a jury trial before you ever spoke to a doctor, and the Supreme Court backed them up. What comes next is worse, because the clause we're about to cover isn't about what happens if something goes wrong. It's about what the hospital is doing with your body's most private information, right now, whether anything went wrong or not. If you're not subscribed to Law Drop yet, do it right now. Hit the subscribe button, tap the bell so you don't miss what's coming, and if this video has already shown you something you didn't know, hit like. It helps more people find this before they sign something they can't take back. Let's keep going. Think about what your medical records actually contain. Your diagnoses, your medications, your surgical history, your mental health treatment, your lab results, your genetic markers in some cases. Information that your employer would pay to know. Information that your insurance company would love to have. Information that, in the wrong hands, could be used to discriminate against you in ways that are very difficult to prove and even harder to fight. That information is in your file, and depending on what you signed in that admission form, you may have already authorized the hospital to share it. Here's how it happens. HIPAA, the federal law that's supposed to protect your health information, has exceptions, big ones. Hospitals can share your data for treatment, for payment, and for what the law calls healthcare operations. That last category is deliberately broad, and hospital attorneys have spent years figuring out exactly how broad it can be stretched. What Stat News found, in an investigation published in 2020 and updated as recently as 2024, is that a growing number of major hospital systems are deploying artificial intelligence tools to analyze patient data, predict outcomes, and guide clinical decisions. UCLA Health was one of them. Their system used a neural network to identify which patients were at risk of being hospitalized in the next year. The patients were not told. The hospital's position was that the tool was part of their quality improvement operations, and that patients consented to its use simply by being admitted. Glenn Cohen, a professor at Harvard Law School, described the industry's approach this way. Hospitals are operating under the assumption that you do not disclose, and that's not really something that has been defended or really thought about. That was 5 years ago. The use of AI in hospital systems has expanded dramatically since then, and the data feeding those systems, It came from admission forms, from the releases patients signed before anyone took their blood pressure. Now consider this. Between 2009 and 2024, healthcare data breaches reported to the federal government exposed the protected health information of approximately 847 million individuals. That is more than 2.5 times the entire population of the United States. In 2024 alone, a single ransomware attack on one company called Change Healthcare exposed data from nearly 193 million Americans. One attack, one company, 1 year. The data you authorize in that admission form doesn't stay in a locked cabinet. It moves. It gets shared. It gets breached. And once it's out, it doesn't come back. And you gave them permission to have it before the procedure even started. Not every state handles this the same way. And where you live, or where you happen to get sick, can make an enormous difference in what rights you actually have when you walk through that hospital door. Let's start with the state that has done the most to protect patients. California. California law requires that arbitration clauses in healthcare contracts be printed separately from the rest of the document, clearly identified and written in plain language. The patient must be told explicitly that signing is not a condition of receiving care. And, this is the part most people don't know, you have 30 days after signing to cancel the arbitration agreement. In writing. 30 days. That right exists in California. In most other states, it doesn't. Montana and New Jersey have also developed stronger consumer protections that courts have used to push back against arbitration clauses that were buried, rushed, or signed under duress. Illinois has specific legislation governing healthcare arbitration that gives courts more room to examine whether the patient truly understood what they were signing. Now let's talk about the other side of the map. In Texas, arbitration clauses in medical contracts are generally enforceable as long as they meet a relatively low bar for disclosure. Courts there have consistently upheld clauses that patients signed without understanding them. Florida follows a similar pattern. Georgia, Ohio, Tennessee. And then there's Kentucky. In a case that should have gotten far more attention than it did, a Kentucky appeals court ruled that a patient diagnosed with stage 3 lung cancer, who had recently undergone a tracheostomy, meaning a surgical opening in his throat to help him breathe, was legally capable of signing a mandatory arbitration agreement during his hospital admission. The court acknowledged he was gravely ill. They acknowledged the circumstances were difficult, and they still upheld the clause. Because under Kentucky law, being seriously ill is not the same as lacking legal capacity to sign a contract. Think about that for a moment. A man who just had surgery on his throat, fighting cancer, being handed paperwork in a hospital bed, and the law says that signature counts. That's not an exception. That's the standard in a majority of American states. But here's what those states, all of them, have in common. There is something you can do in that moment. Something simple. Something that most hospital employees have never been asked about. And it works. Here's what the hospital doesn't tell you. You don't have to sign everything. Most Americans have no idea because nobody at the front desk mentions it, and the entire system is designed to move you through as fast as possible. But you have options, 4 of them. Some attorneys recommend the following approaches, though your state and situation may vary. First, before any planned procedure, call ahead and ask for the admission paperwork in advance. Read it at home when you're not rushed and not in pain. Most hospitals will send it. Some will push back. Ask again and document that you asked. Second, cross out the clauses you don't agree with and initial next to each one. This creates a written record that you did not consent to that specific provision. In most states, this is legally meaningful. Third, and most direct, write these words next to your signature on the arbitration clause. I do not consent to arbitration. Courts in some states have treated that kind of documented objection as evidence the clause wasn't freely entered into. Fourth, California only. If you signed a healthcare arbitration agreement within the last 30 days, you can cancel it. Send a written notice to the hospital's legal department invoking California Health and Safety Code Section 1363.1. Certified mail. Keep a copy. None of this is guaranteed. Depending on your state and your judge, a crossed-out clause may or may not hold. But doing nothing guarantees the default outcome, the one the hospital wrote. There is, however, one situation where none of this is even possible, where you can't cross anything out, can't write anything, can't ask any questions. And it's the moment when you need protection the most. The emergency room is different, not because the hospital treats you differently, but because you do. When you walk into an ER, you're not a person planning a procedure. You're a person in crisis. You may be in severe pain. You may be disoriented. You may have arrived by ambulance, unconscious, and someone else, a spouse, a parent, an adult child, is handling the paperwork on your behalf. And that person, standing in a fluorescent-lit hallway at 2 a.m, scared out of their mind, is being handed the same stack of documents. Federal law does offer one protection here. The Emergency Medical Treatment and Labor Act, EMTALA, requires any hospital that receives federal funding to provide stabilizing treatment to any patient who arrives in an emergency, regardless of their ability to pay or their insurance status. The hospital cannot turn you away because you haven't signed anything. But EMTALA stops there. It does not say the hospital can't hand you documents while you're waiting. It does not say they can't ask your family member to sign while you're being treated. And it does not protect you from the legal consequences of whatever gets signed in that hallway. Courts in multiple states have addressed this directly. The question they've been asked is, can a mandatory arbitration clause be enforced when it was signed during a medical emergency, under duress, by someone who had no real opportunity to review it? In most states, the answer has been yes. There are exceptions. Courts have occasionally thrown out clauses signed by patients who were documented as lacking capacity, unconscious, heavily medicated, in active crisis. But the bar for proving incapacity is high, and the burden of proving it falls on you, not on the hospital. What EMTALA guarantees is the right to be stabilized. What it does not guarantee is anything that happens on paper while that stabilization is occurring. Which brings us to the one thing that changes all of this. The one piece of information that no hospital admission form mentions. The one move that, if you make it before you ever need it, puts you in a fundamentally different position than every other patient walking through that door. Here's what I promised you at the beginning, the exact words that change everything. But before I give them to you, I need you to understand something. Because these words only work if you use them before you need them. Not in the ER, not when you're scared, not when someone is handing you a tablet and pointing to the signature line. Before. For any planned hospitalization, any procedure you can schedule, you have the right to contact the hospital in advance and request the admission documents. And when you get them, you write this at the top of the conditions of admission before you sign anything. I reserve the right to refuse specific terms in this agreement. I do not consent to mandatory arbitration. Then you initial it, then you sign. That's it. Will every hospital accept it? No. Some will tell you the form is non-negotiable. Some will ask you to speak with an administrator. In rare cases, a facility may say they can't proceed, though for any non-emergency procedure, pushing back on that is worth doing, and an attorney can help you understand your options in your state. But here's what that sentence does. It creates a written record dated before treatment that you did not freely enter into the arbitration clause. It establishes that you were aware of it, that you objected to it, and that your signature on the broader document was not intended as blanket consent to every provision inside it. In some states, courts have considered exactly this kind of pre-treatment documentation when patients later challenged arbitration clauses. It doesn't guarantee victory, but it changes the conversation entirely. Now, this is the part I want you to really sit with. The hospital paid attorneys to write that admission form. Those attorneys spent time making sure every clause would hold up in court. They anticipated that patients would sign without reading. They designed the document around that assumption. The data you authorize in that form, your diagnoses, your surgical history, your medications, your mental health records, is worth enough that a single breach of healthcare data cost an institution an average of $7.42 million to resolve. That's what it costs them when it goes wrong. What does it cost you? A moment, a pen, and knowing what to write before you walk through the door. This video is for informational purposes only and does not constitute legal advice. Laws vary by state and your situation may be different. Always consult a licensed attorney for guidance specific to your circumstances. Someone in your life is going to a hospital soon. Maybe it's you. Maybe it's someone you love. And when they get there, they're going to be handed that stack of papers. Send them this video before that happens. If Law Drop helped you today, hit like, subscribe, and ring that bell. And drop the word "signed" in the comments if this changed the way you think about that waiting room clipboard. You just learned what hospitals hide in their admission forms. Next video, that streaming service you've been trying to cancel? California just made their auto renewal trap illegal. Your state probably hasn't caught up yet, and the clause they're using looks a lot like the one we just talked about. That's next.